Hello, everyone. Hello, everyone. Welcome to our fourth session of the School Choice in the Post-Pandemic Era Conference, hosted by Harvard Kennedy School's Program on Education Policy and Governance. My name is Michael Poor. I'm on staff at the Program on Education Policy and Governance. We're going to take a few minutes to allow people into the webinar. So please just bear with us and we'll get the conference session underway momentarily. As a reminder, there is closed captioning available. You can toggle that on and off as you desire at the bottom of your Zoom screen. So we'll give everyone just a moment longer. You can see the session information on your screen as we prepare to begin today. Thank you again for being here. And I'm going to hand things off to Professor Daniel Hamlin of the University of Oklahoma now.
Thank you, Michael. So welcome everyone to this fourth session on school choice in the post-pandemic era. This conference is a virtual webinar series that is held weekly from 12 to 1 p.m. each Friday through December 10th. The conference is also sponsored by the Program on Education Policy and Governance, known as PEPG, at the Harvard Kennedy School of Government. It's great to see all of you joining us. I know some are still trickling in. My name is Daniel Hamlin. I'm Professor of Education at the University of Oklahoma, and I'm also a PEPG research affiliate, and I'll be moderating today's session. In 2018, the Supreme Court ruled in Espinoza versus Montana Department of Revenue that Montana's tax credit scholarship program could not exclude religious schools from participating in the program. The court said that the no aid clause in Montana's constitution that prohibited aid to religious schools was unconstitutional. No aid clauses, or what are sometimes called Blaine amendments, are considered to be a relic of anti-Catholic prejudice in the 19th century. But what exactly is a Blaine amendment, and does the ruling in Montana apply to other state bans on aid to religious schools? The Supreme Court is being asked to rule on these questions in its current session, and today we have three of the nation's top legal experts in this area to help unpack these questions and explain how the issues that are now before the Supreme Court, as well as other state courts across the country, are shaking out. Before we turn to our panelists, I want to recognize Antonio Wendland, Nick Tavares, and Michael Poor, who have carried the administrative and technical workload for the conference. Thank you. And of course, if you miss a session, you can view a recording of each session on PEPG's website, which is typically posted 2 or 3 days after the event on Friday. Okay, let's turn to our panelists now. So our first panelist is Michael Bindas, senior attorney at the Institute for Justice. He was part of the Institute of Justice's legal litigation team in the landmark, or what many are saying is landmark, Espinoza versus Montana Department of Revenue case. He is currently leading the legal challenge to Maine's exclusion of religious options from its educational choice program there. Our next panelist is Joshua Dunn. He is professor of political science at the University of Colorado. He writes a quarterly article on law and education for Education Next and has written several books, and is also co-editor of an important collection entitled From Schoolhouse to Courthouse. Finally, we have Daniel Suhr. He's managing attorney at the Liberty Justice Center. He is attorney for the plaintiffs in a fascinating lawsuit that's currently underway in South Carolina. We'll be talking to him about that. Before we begin, a quick note to the audience. We certainly want to hear from you, and please do post your questions. We'd love to go ahead and pose those to the panelists, but do make sure that you keep your questions brief so that I can pick them out from the Q&A chat box and pose them. So yes, please do get involved and pose some questions, and I will dig them up so long as you have a clear and short question for me to find. So with that, I'm going to start off with the session question. Does the Constitution require school choice? And we'll give each panelist about 3 or 4 minutes to give their thoughts on that, and then we'll confer about each other's responses, and then move to talk about specific cases in Maine, South Carolina, and Michigan. So Michael, if it's all right, can we start with you?
Absolutely, yeah. So it's important to keep the question in mind here. So does this Constitution require school choice? That's a slightly different question from whether the Constitution permits school choice and whether religious schools can participate if it does permit school choice. So starting with that first question, does it require school choice? Under current law, the answer to that question is no. In fact, the United States Supreme Court, in a case back in 1972, affirmed a lower court decision rejecting the argument that parents are entitled to a share of public money to send their children to private, including religious schools. That case, it was called Brusca versus State Department of Education, and it arose out of Missouri. And a group of parents said, look, Missouri has a compulsory education law. They're forcing our children to go to school. They'll pay for that school if it's a public school, but we have a federal constitutional right that the Supreme Court has already recognized to opt out of the public school system. And so when you put all that together, the state, again, forcing kids to go to school, willing to pay if it's public, but we have a right not to go to the public school. The only way to reconcile all of that is to say, let the money follow the child to the private school of their choice. And a 3-judge district court panel rejected the argument, and the US Supreme Court affirmed that decision. Now, there are three things really, I think, that bear on how precedential that decision is. The first is it was a summary affirmance. And what that means is the Supreme Court affirmed the decision without an opinion. That's still a decision of the case on the merits of the case and is precedential. But I would argue that it's not quite as precedential as a fully reasoned opinion of the court, where the court is setting out its own reasons for the judgment. But nevertheless, it's entitled to some degree of precedential weight. Number two, that decision that the Supreme Court affirmed assumed that Missouri's Blaine Amendment, which we'll talk about the Blaine Amendments here in a bit, but presumed it was constitutional under the federal Constitution. We now know that Blaine Amendments have serious federal constitutional problems. And in fact, the Trinity Lutheran case from 2017 involved Missouri's Blaine Amendment specifically and held that the state had unconstitutionally applied its Blaine Amendment. So the jurisprudence concerning the constitutionality of Blaine Amendments has changed significantly since this Brusca case was resolved. And then the third thing, the parents in that Brusca case, this 1972 Missouri case, never alleged that their faith precluded them from attending a public school. And the court highlighted that point in its decision. And arguably, conditions have changed in public schools where there is a significantly greater opportunity for the things taught in public schools to conflict with people of faith, people with sincerely held religious beliefs. And so perhaps that has changed as well. So all of this is to say, under current law, no, school choice is not constitutionally required. Are there colorable arguments that it should be? I think there are. One of the most convincing that I've seen in quite a while was an opinion piece by Columbia law professor Philip Hamburger in the Wall Street Journal just a week ago, where he looked at this as a matter of free speech. And he argued, look, education is speech. Public schools are government speech. And if you have a compulsory school law, you're forcing kids to subject themselves to government speech. And if they don't have the means or the resources to opt out, to choose a private school or to homeschool, they are quite literally trapped into 6 hours a day of hearing speech that conflicts with their religious beliefs, their worldview, whatever. And so he said, this is a fundamental free speech violation. And the only way to remedy that is to offer vouchers or tax credits to enable at least parents without the means to do so to opt out of the public school system. I think, it's a colorable argument. I think the world of Professor Hamburger, he's one of the greatest constitutional scholars living right now. I'm not so sure a court is willing to embrace the argument, at least not right now. And so what we at the Institute for Justice do is urge legislatures to adopt school choice programs rather than asking courts to effectively impose school choice programs. Now, legislatures will adopt them, they will inevitably be challenged, and that's when you get into the other questions that I flagged at the outset. Is school choice permissible if a legislature adopts it? can a religious school participate in a school choice program? And can a state exclude religious schools if it adopts a school choice program? Those are different questions. But as to the first question, does the Constitution require choice? Under current law, no, it does not.
Thank you, Michael. Daniel, can we turn to you now?
So I agree with everything Michael just said. That was a very accurate statement of the law. And generally, my test in these cases is, could I convince Brett Kavanaugh of this? And I'm not even sure I could convince Clarence Thomas of Professor Hamburger's thesis, as much as I might personally agree with it. So let me take a little bit different tact in that case with the stipulation that I think Michael's right. There are actually 51 constitutions in our country. There is a federal constitution that Michael has discussed, but there are also 50 state constitutions. And I think state constitutions actually do potentially offer a tool to expand school choice. And here's why. Lots of states have some sort of uniformity clause in their state constitution, which guarantees some sort of educational access right for students in their state. And we've seen lots of people, maybe on the other side of the aisle from me, who have used those clauses to establish very robust rights to education. And you'll even see lines like, the quality of your education should not depend on your parents' zip code, which is something we all would agree with as a policy matter as school choice advocates. But I actually think there's a potential legal principle there, namely that in some states, school choice programs exist, but they are limited. So for instance, we represent a group of parents in Vermont who do not live in communities that are small enough to have town tuitioning, which is Vermont's solution to rural communities that are so small they can't even support a public school. And so they give a voucher that students can take to private schools nearby. And our argument is, okay, if the quality of your education or your right to education, or your access to education should not depend, why is it that these families in these zip codes get one type of education, and yet our families can't access those same resources to get a school choice education that fits their family? So I think state constitutions and these equity and equality clauses potentially offer a vehicle to at least create some leverage to move the law in the right direction. It's admittedly aggressive, maybe less aggressive than Professor Hamburger, hopefully, but no less aggressive. But I think that they are a useful starting point to see if we can move the law in a good direction.
Thank you, Daniel. Josh.
Great, thanks for having me. So I also agree with everything that's been said so far, but I do want to go back and talk about the Espinoza decision a little bit, because I think you can make an argument based on some of the language in Espinoza for a constitutional requirement of school choice. Now, again, I don't know that the Supreme Court is anywhere close to being willing to accept it, but it's there. And in fact, one of the dissenters, Justice Breyer, actually saw this in the majority decision and is quite worried about it. So since Justice Breyer seems to see it looming out there, I think it's reasonable to consider it as a possibility. So if you go back to the Espinoza decision, Chief Justice Roberts in the 5-4 majority struck down overturned the Montana Supreme Court's decision, which eliminated the tax credit scholarship program in Montana because it cut religious schools and religious parents off from otherwise available benefits, Now, he left in place this distinction that you had in the Trinity Lutheran versus Comer decision of religious status versus religious use. And that's going to come up in some of the cases that we'll be discussing in a few minutes. I really think that that distinction is not long for this world. I think it's unsustainable, and it's probably going to not be there by next summer is my guess. But you go and look at and then you also look at the others who joined Chief Justice Roberts. Obviously, Roberts is a minimalist. He wants to take gradual steps. And you see it in some of the other concurrences, though, people willing to be much more aggressive. Of course, Justice Gorsuch really goes after the religious status versus religious use distinction. Justice Thomas really wants to address whether or not the establishment clause can even be applied to the states. So he's really willing to push much farther. But then Justice Alito, in his concurrence, points out the sordid bigoted history behind Blaine amendments, and thinks that that on its own should be justification for striking down fully striking down Blaine amendments, because in the decision, they didn't fully get rid of the Blaine amendments. And so I think you see some eagerness on the part of at least some of the justices to go farther. My guess is that Justice Barrett is going to be in that camp. So then it does come down to what Chief Justice Roberts and Justice Kavanaugh are willing to do. But then you go to the dissent that I mentioned of Justice Breyer. He had joined the majority in the Trinity Lutheran decision. And he said, well, that was fine. That was really unconstitutional religious discrimination because it didn't involve religious instruction. It just involved surfacing of a playground. But this actually supports the Espinoza decision. It allows for the direct support of religious instruction through these tax credit benefits. And he wasn't willing to support that. But what really troubled him was that phrase that Chief Justice Roberts used, that people were cut off from otherwise available benefits. So here's what he said. If making scholarships available to only secular non-public schools exerts coercive pressure on parents whose faith impels them to enroll their children in religious schools, then how is a state decision to fund only secular public schools any less coercive? Under the majority's reasoning, the parents in both cases are put to a choice between their beliefs and a taxpayer-sponsored education. Then he went on, what about charter schools? States vary widely in how they permit charter schools to be structured, funded, and controlled. How would the majority's rule distinguish between those states in which support for charter schools is akin to public school funding and those in which it triggers a constitutional obligation to fund private religious schools? So he sees that this language can be expanded and expanded rather aggressively, and he's concerned about it. So coming out of the Espinoza decision, I saw really 4 categories of types of legal challenges. And so moving in order from, I think, the easiest challenges to the one that's probably going to be most difficult, which would directly address is school choice constitutionally required. The first would be, what about faith-based schools that have been denied the right to participate in choice programs because of their religious affiliations? I think those kinds of restrictions are going to fall. There are cases in the works. We're going to talk about some of them where that's going to end. Well, what about religious organizations that want to run a charter school, but say they want to do so on a non-sectarian basis? And a state chartering authority says, well, you can't because of your religious affiliation. I don't see that surviving either. Third, what about religious organizations that want to run explicitly religious charter schools? This is getting more difficult, but I could see people making a case that would appeal to 5 justices that they shouldn't be excluded from those kinds of programs. And then finally would be, what about individuals who argue that government funding of public schools is an otherwise available benefit that should then be allowed to support vouchers for them to have their children attend private religious school, or even to homeschool in a more religious context within the home or within their family. So I think it's a possibility. It's certainly not going to happen anytime soon, but there's definitely going to be some chipping away at this, which will, I think, push us in that direction.
Right. Well, thank you, Josh. So is in Montana's state constitution, the no aid clause, was that a typical Blaine amendment?
Yes, it was.
Okay.
It was. There's variation in language in these provisions from state to state, but the gist of them all is the same. And of course, there's the whole origin story of these provisions, which is, I don't know if we have the time, but I'd be happy to address that if I want a short history of where these things come from, so people understand what they are.
Well, can we orient things a little bit? What is a Blaine amendment? Maybe a little bit of background on these, just so that everyone in the audience has a sense of exactly what the Blaine amendments are.
Yeah. So these are state constitutional provisions that are found in 37 state constitutions. And basically what they do is prohibit government from providing funds to so-called sectarian institutions, schools, other religious organizations. And in order to appreciate what these things are, it's important to understand their history. They date back to a time when the public schools were far different than the public schools of today. Okay, so we're talking the 19th century now. The public schools were overtly religious. There was Bible reading, there was hymn singing, there was prayer. It was always from the Protestant perspective, however, because that was the dominant religion in the country at the time. As Catholic immigration increased later on in the 19th century, you now had a situation where Catholic kids were being compelled to attend what were effectively Protestant public schools and to engage in Protestant religious exercises. And you have many stories, even court opinions concerning Catholic kids who were beaten, expelled from public schools for refusing to engage in these Protestant religious exercises. Catholics began advocating for better treatment in the public schools. When that didn't work, they began advocating for a share of the public school funds so they could set up their own schools that were consistent with their faith. And you can imagine how that went over. There was a virulent anti-Catholic backlash in the country, and happy to ride that wave of anti-Catholicism was a gentleman named James G. Blaine, who had been the Speaker of the House, was then a senator gearing up to run for president in 1876. He introduces a federal constitutional amendment that would do two things. It would preserve the religious Protestant nature of the public schools, but prohibit government funding of so-called sectarian schools, which everyone understood to mean Catholic schools that were showing up across the country at that point. It received an overwhelming majority vote in the House. Thankfully, it fell a couple votes shy of the supermajority it needed in the Senate to go on to the states for ratification. But Blaine and his cronies did through the back door what they couldn't do through the front. As new states came into the Union, they required states to include Blaine language in their state constitutions. And that's how we wind up with 37 state constitutions that prohibit government from funding sectarian schools or other sectarian organizations.
Thanks, Mike. And wasn't Blaine himself, I may be getting this wrong, but wasn't Blaine himself a Catholic?
He was not a Catholic. He had family members who were Catholic. And there's a spirited debate about whether he himself was anti-Catholic or instead just merely an opportunist who was happy to ride anti-Catholicism to the White House. At best, he was an opportunist. At worst, he was a bigot.
All right, so a little bit of background there on the Blaine amendments, which will be emerging in some of these cases that we'll be looking at in Maine, South Carolina, and Michigan. So why don't we circle back to Maine? Daniel, maybe we could turn to you and talk about what's going on in South Carolina. I've read up a little bit on the case. It seems quite complicated with some unexpected partnerships. So could you talk a little bit about what's going on in South Carolina? I know the Blaine amendments are a part of the conversation in that case. So can you tell us a little bit about that case?
Yeah, absolutely, Dan. Thank you. So as Michael said, about 37 states have these Blaine amendments, but they're each written slightly differently, just as a quirk of their history, the time they were passed, who wrote them. And so in about a dozen states, the way that the amendment is worded, it applies more broadly than just a religious school. So rather than saying no sectarian school shall receive public funds, it'll say something like no non-public school or non-government controlled school or religious or private school shall receive public funds. They're passed at the same time. They're supported by the same people. But because of this little quirk, they don't really fit neatly into the great win that Michael and friends helped secure in Espinoza, right? Because Espinoza says if it discriminates based on religious status, that's unconstitutional. Well, in South Carolina, in these dozen states, it doesn't discriminate based on religious status. It discriminates based on private or non-public status. And so a secular Montessori school or a secular college prep academy is subject to the same constitutional restrictions as a Catholic school or a Lutheran school. And so they aren't solved by Espinoza. And South Carolina is one of these states. So we represent the South Carolina Catholic school system, and actually also the South Carolina independent colleges and universities, which includes 5 historically Black colleges and universities, in attacking their Blaine Amendment, not based on its text, but on its history. So for those of you who've read the Supreme Court's decision in Espinoza, we're very excited about Justice Alito's concurring opinion, where he goes through this awful history. And he says, there are these other cases where the Supreme Court has struck down bigoted laws that look neutral on their face, but are actually bigoted underneath. And if that's the principle we're going to apply in these other settings, criminal justice, immigration, if that's the principle, zoning, that we're going to apply in these other settings of a neutral law with a bigoted motivation, we should look at Blaine amendments the same way. As we've dug into the history in South Carolina, what we found so interesting is not only was the Blaine Amendment adopted for religiously bigoted reasons against Catholics, but there's this other layer of history that it was a bipartisan cause in South Carolina because Democrats in 1895 were writing the state constitution, want to suppress the northern missionary schools that have come down during Reconstruction and are teaching newly freed slaves to read. The 1895 Constitution in South Carolina, its signature feature is a literacy test for voting. Well, a literacy test for voting does you no good if northern missionary schools are teaching newly freed slaves to read. Defeats the purpose. And so we believe that the 1895 Constitution in South Carolina incorporates a Blaine Amendment, not only because of the anti-Catholic sentiment, fear of Catholic immigration, but also, which was motivating the Republicans at the time, but also the Democrats got on board because of the racial implications of it. And sadly, as we're seeing in our clients now, not only are these Catholic schools I represent being denied equal access to COVID-19 relief funding, but in fact, the historically Black colleges have been denied millions of dollars in federal COVID aid that flows through the state because this Blaine Amendment is still on the books.
So Daniel, on the other side of this litigation, it's my understanding that the NAACP is on the other. If I've got this incorrect.
No, you'd think you would have it incorrect, but this is just, I think, to illustrate how much what is right or what is historical will be tossed overboard in pursuit of an ideological agenda. So we sued the governor of South Carolina because he's the one administering these COVID funds. And the NAACP came in asking to join the case as a defendant alongside the governor. And they were represented by a clinic at Georgetown University Law Center. So just so we're all clear, a Catholic law school is paying its lawyers for free to minimize anti-Catholic prejudice, to stop funds from going to Catholic schools. And the NAACP is coming in to minimize racial prejudice in South Carolina's history, to stop funds from going to historically Black colleges and universities, because they want to stop school choice that much. They're willing to take those positions in court because they know if we win, it will open the door to school choice, and they are that desperate to stop school choice.
So it will still seem a little peculiar to some, especially the NAACP's role. What exactly is their rationale that at least you're hearing?
Yeah, so a lot of this is the same sides that we see in these fights in other places as well. So Americans United for the separation of church and state has come in as an amicus in the case. A lot of the public school groups, the teachers unions have been engaged, all on the other side. And they tell the same story, which is just back in 1895, people loved public schools just that much that they wanted to stop competition from any private schools because they just loved their public schools that much. And there is evidence in the historical record that they have cited to say, in the latter half of the 1800s, that's when public schools as a thing are kind of starting in many communities. We're getting systems for the first time statewide and not just individual community schools. I think the problem with it is the Supreme Court, in a series of cases, has directly tagged Blaine amendments as bigoted. Like the Supreme Court has heard the same evidence that the NAACP and Georgetown and Americans United are relying on now. This is not a new historical story or interpretation of the historical facts. And in 3 or 4 cases, the US Supreme Court has consistently said, even Justice Breyer has said, that this is about religious bigotry against Catholics. That's the underlying cause of these Blaine amendments, and not this alternate story that people just love their public schools.
Well, it's a fascinating case for many reasons. So thank you, Daniel. Josh, what's going on in Michigan? Also an interesting, some interesting dynamics there as well.
Yeah, so this was a case I honestly didn't see coming, but it was filed just last month, and it gets a little complicated, but nevertheless, like I said, it's pretty fascinating. So it goes back to 2 things: the 2017 Tax Cut and Jobs Act. So in that act, it made it possible for parents to use their 529 accounts to also support qualifying K through 12 expenses at private schools, both secular and religious private schools. Now in Michigan, though, they have a Blaine amendment, but it was added in 1970, and in their Blaine amendment, it says that no public funds can go to any private school, whether secular or religious. So it has a kind of veneer of neutrality. It's all kind of like South Carolina, similar kinds of claims. We just aren't allowing any funds to go to any private schools. And it in the Constitution, it specifically mentions tax credits as a kind of aid that cannot go to private schools. So there are parents who have wanted to use their 529 funds to help support expenses at the private religious schools that they send their kids to, and they've been excluded from this. They haven't been allowed to. So now they've sued. And what their argument is that even though there's this veneer of neutrality with Michigan's 1970 Blaine Amendment, that really underneath it was motivated by anti-religious bigotry, and particularly anti-Catholic bigotry. What had happened was there was a proposal in Michigan back in the late 60s to provide $150 for private school students, a stipend for private school students. And this was opposed. There's an organization that was formed to oppose this stipend, and it officially called itself this, the Council Against Parochiaid. And they actually sent out mailers saying asking all of its supporters to contact all Protestant ministers and Jewish rabbis in your area, asking them to sermonize against parochiaid and encourage their congregation to vote yes on the amendment. Then Americans United for Separation of Church and State simply said this in campaigning for the Blaine Amendment: more than 90% of all parochiaid funds go to schools owned by the clergy of one politically active church. So it was no real secret who they were targeting with the Blaine Amendment. And so this thing goes to Justice Alito's concurrence in Espinoza. Even though there's a veneer of neutrality, perhaps the Blaine Amendment should still be considered unconstitutional because of its the animus motivating it, the anti-religious behind it. And they point to other cases like Church of Lukumi Babalu IA, and then also the Masterpiece Cake Shop case, where they said, look, government has an obligation to try and remain neutral towards religion and not be hostile toward it. And the argument of the parents is the Blaine Amendment was clearly motivated by hostility towards religion.
So thank you, Joshua. So Michael, maybe we could circle back now to the main case. It seems like it's one that will potentially have pretty profound ramifications, and it's the Carson case, if I'm correct on that. It's before the Supreme Court now. Could you talk about what's going on with Maine? And my understanding is that the case kind of differs a little bit from the Espinoza case in important ways.
Yes, due to the creativity of the First Circuit Court of Appeals. So Maine, like many New England states, is a largely rural state, and there are parts of the state that don't have the population to sustain a public school. And so to deal with that situation, the state says, look, if a town doesn't operate a public school, or if it doesn't contract with a school to educate the resident students of that town, then it has to pay the parents tuition funds to use at the school of their choice for their child. That school can be public. So in a neighboring town, for example, you can use the money to attend a public school in a neighboring town. It can be private. It can be in Maine. It can be outside of Maine. It can be outside of the country. You can select any of these public or private options, literally anywhere in the world, but you better not dare select a Jewish day school or an Islamic school or the Catholic school around the corner from your house, because Maine flatly prohibits any sectarian school, what it deems to be a sectarian school. So we challenged this sectarian exclusion. We actually filed a lawsuit before the Supreme Court decided the Espinoza case, and it was making its way up through the federal courts. And once we were up at the First Circuit, the Espinoza decision comes out, and you think, seems pretty clear that Maine's sectarian exclusion is unconstitutional, given that the US Supreme Court just said you cannot exclude a religious school from a school choice program. Seemed pretty clear to everyone except the First Circuit Court of Appeals, which said, yeah, we recognize Espinoza said that, but that's not really what's going on here. See, in Espinoza, the court said you can't exclude a school because it is religious, because it has a religious status. That's not what Maine's doing. Maine's not excluding schools because they are religious. They're excluding schools because they do religious stuff, like teach religion. Imagine that. And somehow in the First Circuit's mind, this was a meaningful constitutional distinction. We, again, in the First Circuit's view, we know you can't discriminate against religious schools, but it's perfectly fine to discriminate against schools because they do religious stuff. And this gets to this whole notion of what has come to be known as a status use distinction. So we petitioned the US Supreme Court to review the First Circuit's decision, and the court announced in July that it would hear the case, and it's going to be argued on December 8th of this year. And I think as Daniel and Josh have suggested, although I would encourage Josh to knock on wood given his prediction here, we feel pretty good about our chances. And I say that for a couple of reasons. Number one, this whole idea of a status use distinction, it really comes down to just how you frame the question you're asking, right? You can ask, is the state discriminating against Lutherans, or is it discriminating against people who do Lutheran stuff? It's the same discrimination either way. It's just two sides of the same coin. And to pretend that there's this meaningful constitutional distinction is just, it's just, I think, nonsensical. Moreover, it's not as if the Free Exercise Clause cares whether you call something more use-y or more status-y. The Free Exercise Clause protects exercise. That implies conduct. Yes, it protects your right to believe. It protects your right to identify as a Jew or a Catholic or a Muslim, but it also protects your right to act in accordance with the dictates of your faith. And if that means selecting a religious school for your child, it protects that as well. So there's no basis for this supposed status use distinction in the text of the Free Exercise Clause. There's no basis for it in the history of the Free Exercise Clause. And there's no basis for it in common sense. Religious schools do religious stuff. That should come as no surprise. And to pretend that there's somehow a constitutionally meaningful distinction there is just silly.
All right. Well, we've got a lot of really good questions here in the chat. Maybe I'll pose a few of them to you all. So this one is a really good one. So it says, one concern about private school choice that has not been mentioned is that private schools can discriminate against students by choosing who they enroll. So if private schools are going to get public money through private school choice programs, will this be an issue? So you're receiving, I guess the question is, will receiving public money come with a commitment to serve all students? So what about this issue of discriminating against students, although you're receiving public funds?
I'm happy to answer that one, or Daniel or Josh, but Espinoza didn't involve that issue. Carson does not involve that issue. Really, I think people are raising this idea of, hey, if you allow religious schools to participate, then you're going to wind up with all these, the public funding discriminatory schools. All of this is an argument to mask the discrimination that Maine itself is engaged in, right? Maine is discriminating against religion, period. You don't justify that by saying, hey, we don't like what this school teaches or that school teaches. So Carson is going to resolve the question of whether a state can discriminate against religion, not whether a private school can have admissions or employment policies consistent with its faith. Now, will those cases be litigated? Are there going to be attempts by states to say, okay, now that we have to let religious schools into these programs, we're going to impose, various anti-discrimination requirements on them? Are some religious schools going to contest those anti-discrimination provisions if they conflict with the school's faith? Yeah, those cases are going to come, but that's not what Espinoza was about. It's not what Carson is about. And that issue is just, that will be resolved another day. And it involves very, very different issues, right? In Carson, what you have is a religiously discriminatory law. On its face, it singles out and excludes religion. When you get into non-discrimination laws, it's a much different question, because there you're talking about religiously neutral non-discrimination provisions that burden, perhaps significantly, the free exercise rights of the schools. And there's a different constitutional analysis there. I won't go into the weeds, but that involves questions, the Smith case that some people may have heard about, much different constitutional question there. Those cases will come, someone's going to litigate those cases. But right now, what we're talking about is whether the state can discriminate against parents simply because they desire a religious education for their child.
Yeah. Daniel, you had a comment on that. So there is a question here in the chat that's somewhat related, where the post says, well, what about LGBTQ students? So if you're a private religious school that's receiving public funds, and maybe there's a decision that's made to exclude LGBTQ students in some way, what about the civil rights of those students? How do you see this?
Yeah, so Michael's right. Those cases not only will be litigated, but I think the first ones are being litigated. And the two who immediately come to mind, our friends at the Alliance Defending Freedom have a case in Maryland over Maryland's tax credit scholarship program, which is a neutral non-discrimination clause. And then in North Carolina, both IJ and Liberty Justice Center represent parties that are defending North Carolina's law, which has already been upheld once by the state Supreme Court, but the teachers union is back. And one of their arguments is that these laws discriminate in ways that are unconstitutional. I think Michael's right that the Supreme Court, in a totally separate line of cases, most recently the Our Lady of Guadalupe case, has been taking a very pro-religious liberty stand for schools in the hiring decisions that they make. That it gives them an opportunity, that I should say the First Amendment protects their right to create a community of common interest, and for the state to say that religious schools can't live out their religious beliefs in order to participate in this program, I think is going to be a stretch. We've seen, I think, some accommodation of that actually in the social services space, right? So we just saw the Supreme Court decide the Fulton v. City of Philadelphia case, and the court didn't go maybe as far as some of us wanted it to go, but there at least the court recognized that Catholic Charities had a right to be Catholic while at the same time serving its clients on adoption, including this question of how it treats people trying to use their service with sexual orientation. So I think the court is already laying down these markers in other places, especially these social services cases like Fulton, and all of that will just apply back when one of these school choice cases finally arrives.
Mm-hmm. In Ontario, Canada, I don't know how familiar you are, they kind of took an opposite direction, where instead of having Blaine amendments, they kind of set up a whole parallel publicly funded Catholic school system. So pretty much in every part of Ontario, you have your sort of traditional public district schools, and then you also have your publicly funded Catholic district schools there. So they kind of just went in an entirely different direction. But there's been a lot of litigation there in the past, and basically it seems to be that the result of that litigation is that those schools that are receiving public monies, they must take all students. So they can't deny students who maybe don't fit with the Catholic ethos. And some have kind of argued, well, one of the results of that is that it kind of waters down the Catholic education. So Josh, how do you kind of see this issue of discrimination of students, potential discrimination of students in schools that are participating in these private school choice programs?
Yeah, so I agree with everything that Michael and Daniel said. This is already being worked out, I think, in the courts. And so far, we've seen the Supreme Court move more in a direction of religious liberty. But I think there is another issue here, which what actually counts as aid to these schools. So we're talking about funding tuition and those kinds of things, but this goes back to, I think, some confusion from the very beginning. What's the Supreme Court really waded into interpreting the Establishment Clause, where it defines separation of it basically inserted separation of church and state into the Establishment Clause, and then started to define it as no aid. That is, you can't give any aid. And initially, they actually had two definitions: neutrality and no aid, but no aid kind of won out. But very early on in this history, some justices on the court, including William O. Douglas, perhaps the justice farthest to the left on the court at the time, recognized that this doesn't really work because, okay, you're giving books. Well, is that okay? Or you're supporting tuition or bus rides, these kinds of things. And you're going to start drawing these really arbitrary lines because you think about it, private schools, religious schools already do receive aid if they're tied into public sewage systems, if they get support from fire departments or the police. How do you actually make reasonable or principled distinctions among different types of aid? And so I think that's actually part of the issue here, is that we've accepted this really unworkable standard, and I think the court even recognized it. And I think you see it even now with what actually are the rules for interpreting the Establishment Clause. We just don't know, right? We think the Lemon test is gone. We think, but maybe it'll rise again from the grave, as Scalia talked about. But it looks like it's gone. But then, if it is gone, then what? All of this stuff, particularly some of the things tied to no aid and entanglement, they might not be there either.
So if I can just add quick, sorry, for the policymakers on the call, I think this is also a reason to think about ESAs over vouchers, right? That when we're talking about these religious liberty implications, if the money hits a parent's account and then the parent has a separate, set of control over it, and there's that much more differentiation or space between when it starts with the state and when it ends with the school, I think those sort of distinctions at the end of the day, may or may not be helpful. But certainly as we think about like what a test case would be on this, I would think that an ESA or something where the parent has maximum control and the dollars of the furthest distance from the state is going to be the best set of facts for us.
And if I could jump in, Dan, building on what Josh and Daniel said is, looking at this as a situation of aid and looking at the Establishment Clause jurisprudence and the points Daniel made, yes, there's aid in a school choice program, whether it's an ESA program, a tax credit program, or a voucher, but it's not aid to schools, it's aid to students. And not a penny flows to any school, religious or non-religious, but for the private and independent choice of parents. So I think it's important to keep that in mind. Yes, this is public funds. Yes, this is aid, but it is not aid to religious schools. It is aid to parents. No one would say the Medicaid program is aid to hospitals. The food stamp program, is aid to grocery stores. It's aid to individuals who exercise genuine independent choice as to where to use those funds. And if a parent wants a religious school that's consistent with their religious views, they should be allowed to choose that.
Yeah. Let's talk about something more controversial. How about religious charter schools? So we've got a couple of good questions on religious charter schools. my understanding of some of the court decisions is that the court so far has kind of made this distinction between religious affiliation and religious endorsement, which I'm not sure I fully understand. But and I know that the federal government also has put out some guidance that says charter schools must be non-sectarian. So what are your thoughts on this issue of religious charter schools? And can well, I'll let you guys pick it up from there.
Anyone want to pick it up? This is an issue that, and at IJ, we focus on private school choice, so we're not involved in charter issues. And from my understanding, just knowing some folks in the charter community, there's a very spirited debate over this very issue, whether religious entities should be allowed to establish charters, and even more directly to provide a religious curriculum through charters. All I can say on this, it's not an area of expertise for me, but there was no direct impact in the Espinoza decision, and I can't imagine there will be any direct impact from the Carson decision on the charter question, because charters, at the end of the day, yes, they're privately operated, they're also public schools, and you get into different situations where you're dealing with public-private distinctions as opposed to religious, non-religious distinctions. And so I think, some of what we may get in a Carson decision will bear on that tangentially. But if anyone's hoping that Carson is going to be the silver bullet that allows religious charters, I just don't think that that's going to happen.
So I just added to the chat box for those of you who are interested in going deeper. Nicole Burnett did an excellent paper on religious charters about a year ago for the Manhattan Institute. So I think that would be a great starting point to go deeper on this. I do think it's going to be an issue that is going to continue to arise, honestly, as we see the evolution of funding models and student models, right? Like we just know populations are changing. And so we've got a lot of Catholic school buildings in urban communities. Again, Professor Burnett has done great work on this in previous law review articles, talking about just the way that those demographics are changing and the reality that we have these empty or low attendance school buildings that are available and students who need help. And so maybe especially in blue states where we can't get full school choice, having charter schools that are converted, from being a previously Catholic school to shutting down to now being a charter school that has a lot of the same staff, but has taken down the crucifixes off the wall, or maybe not. Like this is going to be a lot of the future in a lot of communities.
So
yeah, I would say that I made this distinction in my initial comments. Let's say you have a nonprofit that wants to start a charter school just to serve the community, and it's a non-religious organization, right? Obviously, there's no problem there. This is where I do think Espinoza creates some problems. If, let's say, a religious nonprofit wants to come in and start a charter school to serve the community, and they say, "Look, we just want to we want to help the kids in our community, and we are not going to offer a religious curriculum. There's not going to be religious instruction. Obviously, their faith might inform how they would provide the education, but there's not going to be classes in doctrine. You don't have to, affirm anything like. I see those kinds of cases as being decided almost by Espinoza. It's going to be really difficult, I think, for states or for local school districts to exclude religious nonprofits. The trickier issue is when it's a religious nonprofit that wants to have an explicitly religious education. You can make some arguments based on Espinoza, but it gets tougher. And I don't know that the Supreme Court's going to accept that anytime soon.
I know your legal minds here, but let me ask you more of a question that would come from a sociologist. So a lot of the critiques that I often hear about private school choice programs or religious charter schools is that what ends up happening is that these programs are going to lead to kind of have this balkanizing effect on the US, that we lose that sort of common language that binds us all together when we have all of these programs and people go off into their own preferred religious schools, and that ultimately this has a negative effect on our democracy. I was wondering if I could get you to give your thoughts on that, because that's a critique I often see more in the sociology literature, let's say, than in the legal one. But I'd be curious to know what your perspective is.
I've always found it ironic that school choice opponents argue that in order to promote diversity and tolerance, you need to have a uniform government monopoly. So I don't buy it.
Okay.
Yeah, so I would point folks, I think Ashley Berner at Johns Hopkins does fantastic work on this, that educational pluralism is an important part of our country's history. In fact, the amicus briefs that we filed in support of Michael in some of his cases have tried to go through this history and show that actually the diversity of our country is reflected in our school system. It has been for centuries, since before the founding. The diversity of our country has been reflected in our schools. And I think Michael's exactly right. Part of the question is just where you define diversity. At what level do you define pluralism? Is it at the individual level, where all students are in these supposedly diverse public schools, but then all of the public schools look exactly alike? Or as a society, are we better off saying we're going to have communities of common interest that are bonded together over shared values or shared interests? Kids go to a nature-based charter school. They love it because everybody else at their school loves nature. It's not religious, it's just outdoors. And they're little boys, they're 8 and 10, and it's totally where they should be in the world. So allowing us to have magnet schools, charter schools focused on arts or other types of education is just as much as allowing us to create a community based on shared values. Yeah, little girls too also love outdoors. It's mostly boys at the school, but little girls too. Whoever wrote in the chat.
I would just say that sounds very similar to the arguments that people made for Blaine amendments. It's exactly the same argument. Well, we can't have all these, Catholics, right? We need to make certain that the Catholic kids get into public school so they become good Protestants. I don't see that there's actually a whole lot of difference between those arguments. Just a century or so of time.
Yeah, and going back to a point I made earlier, and building on what Josh said, when the Blaine movement arose, you had many situations where Catholic kids were being beaten and expelled from public schools for refusing to participate in these Protestant exercises. One of those cases arose out of Maine. It was a young girl named Bridget Donahoe, who, along with 16 of her classmates, was expelled from a Maine public school for precisely this reason. She challenged her expulsion. It went up all the way to the Maine Supreme Court, which upheld her expulsion in an opinion that's dripping with nativist anti-Catholic bigotry. And the closing paragraph of that point basically said, I'm paraphrasing a bit, but not much. You have uneducated masses coming to our shores, weaken the strength of our midst, I think was the phrase. And the only way to ensure, again, paraphrasing a bit, that they can become good Americans is through the public school system. So again, that argument, the one you articulated, Daniel, is the very argument that was used to justify compelling Catholic kids to go to the public schools, to Protestantize them, to Americanize them, to make them good citizens and loyal Americans. So, I think that's just history repeating itself here.
Yeah. So we're getting near the end of the hour here. I have to ask you, because we have a lot of homeschoolers who watch our sessions, and we did a conference on homeschooling and covered regulation, and that was really a hot button topic during that conference. So what are your thoughts on the state's ability can the states regulate homeschooling in certain ways? So can they require families who decide to homeschool that they have to visit a doctor once a year, or that they have to present academic materials to regulators? If you could give your thoughts from a legal standpoint, can states require certain regulations on homeschooling? Daniel, you want to take it?
Yeah, so I mean, obviously, I think one of the things we've seen that's been so interesting about the last year is this line between homeschooling co-ops and pods and education. Like that, this has been a really, I think, kind of fun, interesting moment for us. And honestly, I'm a little surprised we haven't seen more of a regulatory crackdown in blue states on these pods because right now. I think the law is in a pretty good place, has been in a pretty good place for a long time, defending parents' rights to homeschool. Basically, the deal that the Supreme Court cut with itself was you don't have a right to public funds to send your kid to a private school, and you don't have a right to tell your public school what your curriculum is. The Supreme Court and Terry McAuliffe sound a lot of light at certain points, but you can always homeschool if you want, right? That's your right. And so the Supreme Court's always been really strong on that. Where we get into, I think, the fuzzier places is these co-ops and these pods that we're seeing more and more popular. And at what point does a homeschool co-op become an unregulated school? I'm honestly surprised we haven't seen more crackdowns in blue states on that. I think it's a good thing. I hope we keep pushing the boundaries of that. But for the moment, the right is strong, but the edges are fuzzy.
Yeah. Well, thank you, Daniel. And I think we've reached the end of the hour. So I just want to thank our panelists today for offering really their insights on these very influential cases. So thank you to all three of you for joining us.
Thank you.
Next week, you're welcome. And next week, we'll be looking at the latest research on digital learning and virtual schools. And we have three really great experts in this area. So please do join us next time for that session. And thank you again.
Thanks again for coming, everyone.